Disability Rights Arizona presents Employment Accommodations for People with Traumatic Brain Injuries. This video will review the employment rights of individuals with traumatic brain injury, or TBI, who may need reasonable accommodations at work. Title I of the Americans with Disabilities Act protects qualified people with disabilities from discrimination on the basis of their disability in the workplace. A qualified individual with a disability is a person who, with or without reasonable accommodations, can perform the essential functions of the job. The ADA applies to most employers, with some specific exceptions. Title I requires employers to provide reasonable accommodations to employees and applicants with disabilities who need them. An accommodation may be needed in the application process or while someone is working on the job. Each request for an accommodation should be evaluated on a case-by-case basis, taking into consideration the facts of the situation. An employer is not required to provide an accommodation that would cause an undue hardship. An accommodation could be considered an undue hardship if it would create significant expense based on the employer's financial resources, or result in significant disruption to the employer's operations. People with TBI may need reasonable accommodations at work in order to do their jobs. A reasonable accommodation can be any physical change to the workplace in order to make it usable for people with disabilities. A reasonable accommodation can also be other changes like part-time or modified work schedules, getting special equipment, devices, or software, changes to training materials, tests, or policies, additional leave, and job restructuring. For example, if an employee with a TBI experiences sensitivity to bright light because of their disability, one accommodation might be to replace the lights in their office with non-fluorescent lighting. Another employee with a TBI might have difficulty remembering all the steps in a process at work. A reasonable accommodation could be the creation of a checklist that helps them to remember the process steps. More workplace reasonable accommodation ideas can be found at the Job Accommodation Network website, askjan.org. There are no magic words to ask for a reasonable accommodation. The employee or applicant can use plain English to say that they are encountering a problem or need something due to their disability. Reasonable accommodation requests can be made verbally or in writing. Putting the request in writing is recommended so that you have a record of the request. When an employee asks for a reasonable accommodation, it should initiate the interactive process, which is a dialogue between the employee and the employer about what is needed. This allows employees and employers to find a reasonable accommodation that allows the employee to perform the essential functions of the job and does not cause the employer undue hardship. Employers don't have to provide the preferred accommodation, but they do have to provide an effective accommodation. Here are some tips for making reasonable accommodation requests in the workplace. If an employee is unable to ask for an accommodation, someone else, like a job coach, vocational rehabilitation counselor, or relative may ask on their behalf. Tip number 1. Put the accommodation request in writing. The request should state that you have a disability and need an accommodation under the ADA. You should explain the link between your disability-related need and what you are requesting. You should ask for the accommodation that you want, or suggest accommodations that might work. Tip number 2. Be sure to engage in the interactive process and document it. Be open to ideas, but advocate for what you need. If you have a meeting with your supervisor to discuss your request, send a follow-up email with what was discussed, key takeaways, and what was agreed to. Tip number 3. Keep notes and save any records related to the reasonable accommodation request. You may need these documents later for reference, or if a dispute arises about what was agreed to. Tip number 4. If your supervisor denies an accommodation that you need, try raising the issue with human resources or at a higher management level. Tip number 5. If your employer ultimately denies the request, you can take steps to enforce your employment rights. You can file a charge of employment discrimination with the Arizona Attorney General's Office Civil Rights Division or the U.S. Equal Employment Opportunity Commission. You have to file a charge first if you want to pursue a lawsuit. Remember, charges should be filed within 180 days of the discrimination for state law or within 300 days of the discrimination for federal law. To access more information about employment rights, visit Disability Rights Arizona's website at disabilityrightsaz.org or call 602-274-6287. The information presented is intended to be used for informational purposes only and is not legal advice. If you have specific questions or want legal advice, please contact a qualified attorney in your state.